That's great. Thank you very much. And thank you very much. And I apologise. I'm between two different committees at the moment. So that bilocation element means that I may ask something that has already been answered, but I'm trying to avoid that. I think you've spoken extensively on the ward of court and how that's going to work. And thank you. But I'm not clear. Will families have to apply to be the committee now, or to insert themselves into decision making on behalf of someone who's an existing ward of court? Will there be a pathway of transition out of that? So that's one question. My next question is, at this moment in time for a next of kin, I completely hear you, and I think that we need to do an information program on explaining to people that next of kin has absolutely no standing. I have had a number of those cases in the past couple of years where people don't understand that and can't understand how they're excluded from information. We've also had a documentary a number of years ago, a primetime documentary of a husband excluded from a care home in the care of his wife, where she needed constant care, and that he was excluded because he alleged he started making complaints, and in that context. So I think that it has a silencing effect on families at the moment. So the way around that in current law would be to establish the power of attorney or enduring power of attorney, so that you have who can make decisions. But that is very expensive. So I suppose my concern is the system that we're putting in place will rely on an application to court, and families having to make an application to court. And so I want to know, has consideration been given to assuring that there's going to be a legal aid provision for that? Or is there an easier way of doing that, of having a pathway to court? Otherwise, it will be those with means that will have access to having a say on their loved one and in the care of their loved one, and those without means will be left in some sort of a wardship arrangement. So thank you. And apologies if I'm covering what you've already said.
Okay, thank you very much, Mary.
Thank you. Yes, in relation to the current wards and the pathway out, yes, there is provision for that review that must take place in relation to all current wards, adult wards numbering something like 2,300 to 2,500. Those applications will be taken by the wardship court, and the court can decide whether the person is to have their autonomy and their decision making restored to them, or whether they need to transition into one of the new supports under the Act. And the new supporter under the Act could be the family member. So they will be involved in that application, able to make representations, and if necessary to be appointed as a decision-making representative. So families shouldn't consider that they are to be sidelined in this process. The court will have that obligation under the guiding principles to hear from those closest to the relevant person and to look at subsisting family relationships. I quite agree there is outstanding work to be done about addressing that established myth around the next of kin. People can feel quite hurt and offended by this, as if there can be a perception that the Act is doing it to them, when in fact I would say that the Act is the solution, filling that gap that has always prevailed. You mentioned EPAs as the current solution, and of course they only work, you can only make one when you have the capacity to do so. So I recognise that advanced planning isn't a route that's available to everybody. You're also correct that it can be an expensive structure to put in place currently, and again we are very keen that costs are not a barrier to this service and to the supports under the Act. And really, if all of us who can plan ahead, then we may avoid the more onerous and off-putting process of having to go to court. And in relation to supports around going to court, the Act amends the Legal Aid Act. I think the amending legislation will further somewhat amend the Legal Aid Act, so if you keep an eye on that. But it does make provision for the relevant person to have fairly ready access to a scheme of legal aid. They don't have to satisfy all of the conditions that would always apply, and legal advice and legal aid is to be made available to other parties to Part 5 applications as well, including family members. So I would hope, again, that the court process is streamlined as far as possible. We've engaged with court services to say, look, can we make the court rules as accessible as possible. Can one form be sufficient rather than lots of, affidavits and motions and supporting documentation, so that the path to court is eased for people, and again that the costs associated with filing a court application are not an off-putting factor?
That's great. Thank you very much. Thank you.
Thank